Virginia's new underinsured motorist law is changing everything, not necessarily for the better. I'm Gary Reinhardt, an AV-rated attorney, national speaker to the insurance industry, law enforcement, and other attorneys. Welcome to Coverage Cast. This is our look at what's trending in the insurance world and what's going to be on your desk in the near future. Today we're going to explore some of the questions that Caldwell Fund and Messersmith is getting about the new Virginia UIM law. First, why? According to the State Corporation Commission, the sole purpose of this change in the law is to expedite underinsured motorist claims. Not fairness, not justice, but to make money be paid. The old system, the irrevocable offer statute, just wasn't working. That attempt to shift the cost of defense from the liability carrier to the UIM carrier was being thwarted by the liability carriers, smartly conditioning subrogation on the waiver of defense fees and costs. Therefore, the General Assembly has taken the next step, and we will be a pay-and-quit state. So when this happens, who defends the tortfeasor? The short answer, no one. When a settlement occurs, the tortfeasor, the plaintiff, and the liability carrier all enter into a release. When that occurs, the liability carrier is done. He owes no more duties to the insured, no more duties to the plaintiff, not even a duty to defend. When that occurs, the tortfeasor then must only cooperate with the UIM carrier in order to avoid further subrogation. The Virginia Code sets out certain things that they must do, and that is the next step, cooperation. What is it? Under the code section now, the tortfeasor must meet with the UIM carrier's attorney within 21 days after being served with the lawsuit, provided that they've been contacted on who to get hold of. They must appear at a deposition and a trial if they're subpoenaed and notified within 21 days of each event. They must meet to answer discovery. And they also have to keep the UIM carrier updated on where they live. Even then, if they don't comply, they have the opportunity to say that they gave it their best shot. Non-cooperation is a rebuttable presumption. If the UIM carrier asserts that the tortfeasor did not cooperate, and then they're wrong and the court rules that they did, the tortfeasor can collect attorney's fees and costs in defending a subrogation action of the UIM defendant. Next, court approval. Does the first settlement with the liability carrier have to be court approved? It does not. This pay and quit part of the statute does not have to be approved. The statute also gives the plaintiff the right of whether or not he wants to approve it. Now, the ultimate settlement with the UIM carrier probably does still need to be approved. What about the defendant you can never find? The statute requires that the tortfeasor, the liability carrier, and the insured, the plaintiff, all enter into a settlement agreement and execute a release. The statute says that this defendant must sign the release. But then the statute says, in the alternative, the UIM carrier can mail a copy of the release by certified letter to the address of the tortfeasor. This creates an ethical dilemma not only for the UIM carrier, but even for the attorneys involved. The liability defense attorney represents the insured tortfeasor, not the UIM carrier, not the liability carrier. Because of this, they have a duty to the person, and if he objects or doesn't agree to the settlement, they're walking a very fine line in who they truly represent. Does this statute apply to property damage? It's a good bet that it does. The new language does not limit itself solely to bodily injury liability and UM coverage. Therefore, you should operate under the assumption that property damage applies. When does this new law come into place? And this is the real issue. The statute says that it applies to policies issued or renewed on or after January 1, 2016. The revisions to the statute, however, do not reference what to do when you have an accident involving a policy issued after January 1, 2016 and before January 1, 2016. We don't know until the court rules which policy will apply. Some seem to think that the liability carrier who triggers this whole thing by making a payment, their policy applies. Some consider, because the UIM statute is where the law change took place, that the coverage providing UIM applies. Still others think that all the policies have to have been issued by January 1, 2016. Regardless, you need to be prepared to operate under two different laws for a long, long time. Let's look at an example. Let's say an accident occurs in 2016 and a policy was issued in 2015. There's a 2-year statute of limitations. That accident that occurred in 2016, a lawsuit doesn't need to be filed until 2018. Virginia allows 1 year to serve a lawsuit. Now we're in 2019. That's when this litigation will start. We have a non-suit involved. You could be in 2020 under the old law. If property damage applies and it's 5-year statute of limitations, before anything else kicks in, the first filing could be in 2021. There's a lot to work through with this statute. A lot of unanswered questions, a lot of issues to be hashed out. If you have questions about this or any other questions that may arise, please call us at Caldwell Fund & Messer Smith. We are one firm, your firm.